conflicts and are instructed to refrain from participating in a matter coming before the subcommittee with respect to which there is a conflict or appearance of conflict. I don't anticipate having any of those. So Suzanne, if we can start with you and you can remind us where we were and what we talked about at the July meeting.
Okay, I'm back again. I'm sorry. I was gone for a second.
Is everybody hearing stuff twice? I'm hearing stuff twice.
I'm not.
Since I did the live stream.
It's because of the live stream. You need to, if
You
that's
close-
open on
close
another
the window.
tab in your, you need to close that for the live stream.
Look for Chrome. It probably open in Chrome, and then you can close that Chrome window.
Sorry. Okay, did that work?
What do you think? Good? Better?
Yep. Okay, so we are working on, we got an inquiry from a law firm that does mostly estate planning work, and their attorneys are constantly getting called to testify, respond to discovery pertaining to estate documents that they prepared, and they would like to find a way to recoup the billable hours. They'd like to put a provision in their retainer agreement that would obligate the estate to pay lawyers' fees after the death of a client if they are called to testify regarding any aspect of the estate documents. And there is actually, and the issue is whether these types of provisions are acceptable under the rule of professional conduct. Originally, there was a proposed opinion submitted that said this one, there was a specific provision that we were presented with, and the proposed opinion said that that was not, that did not pass the requirements of Rule 1.5A or 5B, but that maybe there would be a provision that might be okay, and that was kind of where the draft left it. And then we had a subcommittee meeting where we were trying to come up with perhaps a provision that would be okay under the rules. At the meeting in July, we talked about what the subcommittee was doing, and that the subcommittee members all felt like this type of provision should be allowed, particularly in the estate planning arena, because subsequent litigation is expected. We got a lot of pushback on that. Todd Brown really, we were talking about limiting the opinion to only estate planning lawyers, and we got a lot of pushback on that. So we might need to rethink that aspect of the opinion, and that's where we are.
So I think a good logical place to start, because we started bandwagoning, as we are prone to do in these subcommittee meetings, and we decided, okay, let's get to yes. How are we going to get to yes? And Preacher Martin over there had us all rolling. So I want to hit the pause button for a second. And I want to ask, since we've got three people from the state bar, when I started thinking about opinions that are limited in scope to a particular arena, because I know it happens, when I started thinking through it, I feel like most of them, the distinction was that they applied in a criminal case, for example, versus a civil case. Is there precedent in civil opinions for us to issue ethics opinions that applies in some contexts, but not other contexts?
I'll pipe up. Yeah, Nicole, what were you gonna say?
I was going to say, not that I'm aware of, not by practice area like that.
Yeah, I was gonna say something similar. I feel like we have, we will limit opinions to address the particular issue at hand,
Right.
to give the context of the principle that's articulated. But I guess the thing, and I think I mentioned this at the July meeting, that one thing we do run into in the disciplinary process is that the folks will argue the applicability of a particular opinion to their disciplinary case, even though it's taken out of the context. And of course, it may not be a successful argument. I want to be clear on that. It's not like it always wins, but I have heard folks argue, well, the principle that's articulated in this particular opinion, even though it's a family law case, it really should apply in this in this particular situation, which originated from a workers' comp or whatever it may be. The principle can get argued. And so that's something to keep in mind here, that I don't know if you can successfully limit an opinion to only apply to an estate context. And I guess particularly when your answer to this question, let's say the answer to the question posed is yes for estates, but it would be no for everything else. If that's the case, then I think we need to be very cautious here.
Or be prepared to write a whole bunch of rules down the road for criminal attorneys on ineffective assistance claims, separation agreements prepared by divorce lawyers. It's going to be hard to rationalize doing it in one arena and not in another. If the same principle applies, that you're being called to be deposed or testify or provide documents.
Well, one distinction in my mind is this is going to be the only practice area where the client's going to be dead. And so if I draft a prenup, we have to go to court over prenups a lot more than we have to go over other domestic contracts. But, my client's going to be alive. And so I can renegotiate if I want to be paid for my fact witness testimony, if I'm being called as a fact witness, or my expert witness testimony, if I'm being called expert witness. I have a client to negotiate a new contemporaneous in time fee agreement with. And so what makes this scenario different than the other civil scenarios in my mind, in one respect, is that the client's dead. Can anybody think of another circumstance where the client would be dead with a contract?
Do you do situations, and I don't know because I don't do separation agreements, where you have a separation agreement in place and one of the parties dies and later on you're called to have to deal with the provisions of that and how it plays out in the state?
No, I have not. I mean, I think if in that scenario, if there was a separation agreement, then a separation to click it in, it's now at issue, and then a death, the separation agreement is going to govern what happens in circumstances of death. When it would really get interesting if there was a separation agreement, a specific performance action, so you have litigation, and then the executor is going to step in to the decedent's position for purposes of an ED or a specific performance trial, just like an ED trial. But I've never had that happen.
I've done one of the Court of Appeals that happened. It was kind of wild, but we were dealing with it many years later. But we were dealing with the disposition of property and whether it was actually affected by a separation agreement or not. And so it came into play.
And the lawyers testified?
On that one, no lawyers testified in that particular one. It was put into play, but we actually ended up in the court, in front of the Supreme Court, had to argue it.
I think that's why this is more akin to prenups to me, because sometimes lawyers end up having to testify when there are issues about disclosure or the timing of things or what the circumstances were when something was notarized, whereas in a separation agreement, almost always all that they're not discrepancies about that. Okay. The validity of the contract itself is not at issue. It's the enforcement of the contract.
Okay.
Yeah, that-
Gina, when you're talking about testifying in those matters, are you acting as a fact witness or are you providing legal services?
So, okay, so by the way you ask the question, I assume that you believe if a lawyer is testifying as an expert witness, that is a legal service.
Expert witness is a different thing than a fact witness.
Right. But you said fact witness or expert witness, and I'm saying, are you saying that if you're, fact witness or lawyer performing legal services, expert testimony is legal services. Do we agree or disagree about that?
I don't know, but
I think that's sort of central. I think it's central to this question though, because, I think it's pretty clear that lawyers can get paid for expert testimony, period, because that's a new legal service. In this scenario we're talking about right now is a fact witness. And if I was being called as a fact witness on a prenuptial agreement, I have never billed anybody for that.
I think if you're an expert witness, you're not providing legal services, you're providing
Legal
expert
opinions.
testimony.
It's usually expert legal testimony.
Yeah, I feel like it's a nuance. I think it's a great point, Gina. That's something that, and I know I'm kind of like jumping into this inquiry again, but I remember looking at this thing early on and we were going, is this legal services, not necessarily as contemplated under the rules? This isn't an attorney-client relationship, but there's some aspects of this proceeding that you'd be a fact witness. But I can see other situations like you're talking about it as an expert witness where you're providing a legal opinion, a legal analysis, and that is a service of some sort, but I don't know that it's a legal service as contemplated under Rule 1.5. First, for example, like as an attorney-client relationship. So but it is some type of service. It's clearly I guess on the spectrum, if you call like fact witness and then like there's something elevated with an expert. Right.
I think it's fact testimony, because you can't be an expert in a case where you are the lawyer and you would essentially be like testifying about your own exercise of due care, of due diligence. So, and what I mean by that is an expert opinion in a case like this would be that, yes, the lawyer properly analyzed whether the person had competency and concluded that she did. And I believe that, they did so properly, And the fact witness is just saying, Mr. Smith walked in my office. I asked him 5 questions. He knew what his property was, etc. That's the testimony. I will tell y'all, the more and more we talk about it, yeah, I'm just saying, the more and more that we talk about it, the less like I feel like the lawyer can be compensated. Just gonna go ahead. Because it is fact testimony, and lawyers get called upon to testify in fact cases and other types of cases as well. So I understand we're trying to distinguish it, but it just feels like it's going to cause a lot of problems.
Well, one thing, I do personal injury work as well. And if I go sit down with a doctor that treated you and you want me I need to get testimony of them giving an opinion as well, I got to pay them an ungodly amount of money.
But there's a statute that covers that, right? That's
So
not
the court actually is the one that will say you can get or you can't get. And there's a statute.
Doctor's not billing an insurance company or a patient for that.
No. I mean, I've got to do it from the personal injury part of it, as far as my client, as far as I'm doing PI work from a plaintiff's perspective. And then also, yes, if you're on defense counsel, you're doing the same thing. But they send us these wonderful invoices for that. Now, there is statutory limitations with regard to workers' comp. Is that what you're talking about?
Well, no, not really.
There's a schedule for fees to be paid.
Well, yeah, there is that, and I believe there's a statute that would compensate, or maybe it's determined by the court.
It's by the court, as I've seen.
But
and they'll testify because they've had to come in and justify their billing rates when it can be obscene. It can be $1,000 an hour, but that's what it is. And they're not actually working on you right then. They're actually just giving you testimony of it. It's horrible sometimes. So I agree. I hear what everyone's saying. I agree too. You would think that if you come call on me and I prepare the will for you, and I charge you $275 for a will, and you walk out the door, and then later on, I'm now getting called to be in a 5-day trial, and prior to that, having to unfortunately answer interrogatories, and then also to assist you with answering interrogatories about what things happen. And then also I've got to go sit for a deposition, and you get to look through my file, and I get to answer all this. I mean, I may end up with 12 to 20 hours just on the low side. And that's a lot of money for this particular service. And I mean, I hear what everybody's saying, hey, wait a minute, you agreed to do it because you charged them $275. Well, $275 for a will and having to sit for, for all these days to answer these questions. I don't know. That's hard to reconcile.
Well, hang on a second. So first of all, I think that I sidetracked us deliberately, but I think it's clear to all of us, or was last time, I think it still is, to Ashley's point, we are talking about fact testimony by a lawyer about the circumstances that existed at the time of a will being drafted when the declarant is dead. Okay, so that's what makes this situation unique. Is if I draft a contract and we're later having a dispute about the fact circumstances, I'm presenting my client who's alive to talk about what frame of mind she was in when she signed this contract and why she was not under duress. For example, in Martin's scenario, he didn't have anybody to bring into court. And so to me, if there's a carve out here, it's because the client is not able to defend his document in court because he's dead.
Right.
And so there's going to be nobody else to do it for him, except maybe his medical doctor, I guess, at the time, except for the lawyer who met with him and videotaped him and asked him the questions before he signed the will. So I think in trying to figure out the problem with wanting to address a narrow issue, I sort of stumbled on the fact that it was the rare circumstance where the client who we're trying to protect can't speak for himself anymore because he's dead. Does that help anybody?
I think, yeah, I'll just say, I think Gina, you're hitting on something. What I was trying to think of other different, what other situations might there be? And I don't know, it always involves us in the state. I mean, maybe it's like is it a business contract? Is it some sort of small business owner that had a contract that now they pass away and the son has inherited and they're not agreeing with the intent of the contract, and suddenly that's being pulled into some sort of dispute, but the person that entered the contract is gone and cannot testify about that, and suddenly the lawyer gets pulled in to talk about, well, what was your conversation with the person at the time they executed that contract for their benefit of their business? Probably the same thing could be said about real property, maybe partitioning real property or assigning rights and all that kind of stuff. I mean, you can get into all those things. And so maybe that's the question of, what is that unique enough that you can create a carve out? I don't know. I think it's a great point. I want to ponder that. But the thing that I was running into before that also, and maybe this is not trying to sidetrack as well, but kind of carrying that through. Let's say we say that's a unique enough circumstance to carve it out. What's the rate? Because you're supposed to draft a contract that obliges an estate or basically creates a pathway for the lawyer to receive compensation. And if this contract, this will, the real estate proceeding, whatever is at dispute or in dispute in this current case, if that is 30 years later, does the lawyer get to charge their rate today, or is it based upon what they were charging at the time the service was originally provided?
So I think they might be stuck with the then rate, and here's why. I mean, the at the time rate,
prevailing rate.
I don't think that the spike in rates in Charlotte, for example, these last few years would have ever been foreseeable to anybody. If you had asked me a few years ago if the going rate for divorce lawyers in Charlotte was going to be $600 an hour in 2023, I would have told you were insane. Just a few years ago, insane. So 30 years down the road, I mean, if Charlotte lawyer rates have doubled in 3 years, you know, it would be unimaginable what lawyers would be charging 30 years down the road. I think that's a bigger problem.
Well, and we need to be concerned with the optics of it. If you've got grandma's estate of, $13,000, and then some lawyer comes out from the path from 17 years ago and comes in and starts billing all this, and the estate dwindles, that's not going to look good for the profession.
Well, and one good thing that'll mitigate against that is I can tell you from an attorney who's filed caveats and who's defended them, 13,000 ain't gonna get it. It's gonna have to be a good bit more to jump in.
Sure.
Because of the expense and the time. You really got to pick the estates, the ones that are worth it. And that's usually what happens. It's not the 13,000 estate. It's the 1.3 or the 5.5. And then you're really dealing with it.
Well, and remember what Martin told us last time. In every scenario, somebody is blessing the fee. It's either the panel, the judge, or who's the third?
Usually you have the judge who's doing it. First thing you charge is the clerk.
The executor.
And the executive.
Okay. There you go.
Susan, and carrying with that, I did send to Suzanne a few minutes ago an email, and that's got a print off from the clerk's manual. That's extremely helpful. We use it a good bit to look at, to give kind of, it's not, they think it's the gospel. We have to show them on occasion that lawyers are worth their salt, and the rule is not quite what they say it is, but it does give you some guidance of what they're thinking when they're going to be approving your fees. And so I sent you the section 6, which is attorney fees and other expenses. If Suzanne can email that to you, you'll see where they break it down between the personal representative employing an attorney or another professional versus the personal representative who is the attorney. And it's a different thing.
But I would think all those people are going to think that a 2053 rate of, $27,000 an hour for a will caveat proceeding is going to be a clearly excessive fee.
Yeah.
And what do you do about a lawyer who was 28 years old when he drafted this and a solo practitioner, and now he's a senior partner. He's Todd Brown in Charlotte. He's charging $1,000 an hour.
Right.
Or he's now the district attorney for Stokes County. He's not even in private practice anymore.
Yeah.
Good points.
Alternative source of income.
Well,
Can I ask a question? Can I ask a dumb question?
I thought that was only I could do that.
Yeah. There's, you were talking about just now the current option that an attorney has to apply for compensation as a witness. And it goes to the clerk or the court itself. You're talking with the executor. Why should that not remain?
And it could, as long as we would say that you could do that. Is ours a prohibition?
I would be more comfortable with that.
You would just do it like
I
you
guess
normally would.
Yeah, that's I guess what I'm saying. Like we're basically providing, like if we said yes to this, we're giving a green light to lawyers to put a clause in that basically says, in the event of my client's death, if any aspect of my legal work is called into question at a later time, your estate shall be liable to me to compensate me for my hourly or for the hours spent defending my legal work that I provided to you. And I think it's easy to see in the estate context. It's like there may be other contexts that come up, but I guess we're kind of putting the lawyer in the driver's seat, so to speak. That's probably a bad term, but the lawyers put this clause in there that takes out of consideration a third party neutral, where the lawyer is saying, hey, I'd like you to, well, I guess maybe they're still involved as far as approving anything coming out of the estate, but to just have it be submitted to the clerk or to the court itself from the get-go, as opposed to saying, I've already got a contract with the decedent, and therefore now with the estate that requires the estate to pay me. Should it just remain that lawyer can apply for reasonable compensation from the court if they're called in, or is that impractical?
And would that require a statutory change?
I mean,
Well, I mean,
Don't they
unless
just
it,
have a claim against the estate for fees owed? I mean,
Yeah.
wouldn't the clerk look at that and the clerk can say, you can have $200 an hour, or you can have $350 or $500 an hour? I mean,
it
Is it-
depends on the priority of the claim.
Right.
Because if you're coming in as a general creditor, unsecured, you're sitting just slightly above the heirs who are the ultimate bottom feeders. And so if this is contracted for by an attorney, and this is self-serving, then there's much better chance that I'll be higher in the pecking order to get paid. And this has to do with us making a living too. But that's where it comes in so many times. If it's almost put in as this is what as contemplated as part of our deal, you will pay us in the event that we get drug into a fight over your will. And I see where the issue gets bigger and bigger, because I mean, I know that there are going to be other attorneys that are going to apply it in business contract debates, in separation agreements, and everywhere. I can see it. It's almost like a Pandora's box. We got to be really, really careful if we want to open it. I mean, we can do it, but I can't say that we'll only get one thing out.
Yeah, I do worry about the ineffective assistance thing, because all
Mhm.
it takes is one person, even if you can scream at folks till you're blue in the face that this only applies in this context. And then a criminal defense lawyer will put that clause in there. If you challenge me for ineffective assistance, then you are agreeing to pay me for the work that I spend proving that I provided sufficient assistance. Is that a deterrent to folks to exercise their rights to challenge something, whether it's the civil or the criminal?
but isn't that a different issue?
It might be, and that's the thing. Is it a different issue, or I'm just saying, could I envision somebody in the disciplinary process arguing that? Yeah.
But I mean, under this opinion, the lawyer is asking, can I charge to be a witness, not to defend the work that I did, but to defend my former client's view, perspective, their wants, what their wishes were, and to further carry out the representation, versus in an ineffective assistance, what the lawyer did is being called into question. So it's not defending what the client wants, it's defending the lawyer. And I think that's a different issue.
I see the distinction.
Exactly. And you're defending the client's documents, not the lawyer's work.
Right.
It's the client's document. It's the client's declaration of what he wanted his estate, how he wanted his estate to be distributed. So you're defending his intention because he is no longer there to tell you what it was.
Right. And if you look at that,
Taxing the non-prevailing party, but that's not something we can do as a
Right.
bar. That would be a statutory change or something a judge would have to consider at some kind of compensation hearing. I don't
You're talking about as far as in the state,
Yeah, look, with the non-prevailing party would pay the
you
fee.
can still tax. As far as, now remember, the non-prevailing, depending on if they get something from the estate, what you can do, and I've had to do this before, is you can actually take from their share. So they receive less because it costs more for what they've done. And so there is an incentive to watch out for if you want to bring this claim and it is not good and you don't have substantial merit for it, then in essence, the clerk has the ability to kind of take from you. And so you could end up losing based on fees assessed just to them. Which, I hate to have that, to have much, but it can't happen. It's a tough one.
Are
The
there
other thing
other
I think-
options, Martin? Like, I guess as far as, like, I guess I'm looking at this as the ultimate goal is to, I don't know, maybe this is wrongly stated. Is the ultimate goal to essentially avoid the lawyer having to spend uncompensated time defending this document? Is a better option kind of the disinherit clause, that type of thing? Or is there something else that would be more for the document to defend itself as opposed to compensating the lawyer to defend it?
Well, the drafting lawyer can only give fact testimony as to, okay, this is what we did. We had
Right.
2 witnesses. There was a notary in the room. We went through time, person, and place. I cannot say it was executed properly and became a legal document that has effect, because then I'm invading the province of the jury.
Sure.
but I can testify that these are all pieces of the recipe. They were all there. And then it's up for the jury to draw the conclusion, did the cake rise?
Wait, we're having
So-
cake now?
No, I use that with my clients. Seems to be the best analogy ever. If you leave out the eggs, it's not going to rise.
Yeah. I see what you're saying.
But and I think y'all are bringing a correct distinction, which is between the idea of fact versus legal opinion. That's a big difference. It's huge. And we're still trying to protect lawyers. Do I want to go through that 20 hours unpaid when I could be doing other things? Well, let's look at somewhere else. Would anybody else have to go through the 20 hours in a profession for which they're licensed? And that's their time they could otherwise be helping clients. Now, most lay people can't practice law, but we can. And so my time is spent at X amount per hour, whether I'm in Charlotte or whether I'm in Wyville. And that'll be a testimony as to that. Am I providing legal services in the truest sense? Well, no, because I'm not actively drafting right then. I'm not expressing an opinion. I can't do that. I can tell you what's happened, but to take my time and otherwise do it, can the court, and Judge, you can tell us this, if I work as an auto mechanic and I need to come testify in court about what went down with the repair to a vehicle for my client or my employer who has been sued, can I submit a fee application? Because I would have otherwise made $15 an hour for the 3 hours I was on the stand. Can you award me to be paid for that?
For lay testimony, I don't think so.
So I guess that's the big distinction. Are we providing what would be considered lay testimony, or are we providing something that could be compensated?
Well,
In your capacity as somebody who prepared the document, I mean, sure, it requires some expertise because you were a lawyer preparing the
Right.
document, just like you're a mechanic testifying about the repairs you made, but you're still a fact witness.
Right? So is it wrong for us to have any expectation whatsoever to be paid? And if that's going to be the case, then my wills go from $275 to $525
Right.
because of the risk. Or if we know this looks really, really questionable, because I know sometimes when it comes in, it's going to be really, really questionable. Mom's ticked off. 2 other children have never come to see her for 10 years. She's got cancer. She knows she's going to die, but she is well within her mind. She does not want anybody inheriting but one child, because that child's been with her through thick and thin. And that's the perfect scenario for somebody to get whacked.
Mm.
And they're going to do it. They're going to bring it because mom's estate's worth $5 million.
Yeah.
And I know it's coming. I can see. I mean, it's that, and that, it,
You know what
it's
you're
a
in
train
for.
coming in the tunnel. It's not the light. It's a train. And it's going to hit me. And it's going to be a mess. Now, do I want to wade into that? Well, I think they need that service performed regardless, because otherwise, you'd only have either fools that don't practice and that are willing to dive into suddenly doing a will for someone. They're willing to do it, not knowing the scenario, or to get so costly that the little lady can't, who only has a $10,000 estate, can't afford to get legal services now. So we got that pulling against us too.
Can I raise a point? So this originally came to Brian from Will Graebe, and there was a proposed engagement letter from the estate planning, what's it called? State Council,
For the firm.
ACTEC,
Yeah.
American College of Trust and State Council. So someone's already dealt with this, I assume, thus there is a form. Yes?
Dealt with it as in somebody's already written that into a contract?
I mean, this has come up before, so Will wouldn't have submitted it to you if this had not come up in other states, or?
Oh, I don't know. Suzanne, I don't think we found
No,
anything.
I was not able to find anything. So, I mean, that, whatever that organization is, that entity presented that provision to their member.
Okay, American
Right.
College of Trust and Estate Council, okay.
Right. And so Lawyers Mutual was looking at ways also, because they're on the hook for this.
Yes.
And so somebody, I think, showed that to Will, and he asked us to look at it and see if it was.
Okay, I just was.
But no,
wanted to-
we haven't ever looked at it before, and I could not find anything from any other state. And I mean, maybe I wasn't putting in the right search terms, but I mean, I could not find anything.
Well, and you know, when we talk about this, we end up always talking about protecting lawyers, but at the end of the day, that's not who we should be thinking about. We should be thinking about the mom with cancer who came into Martin's office and wants her intentions to be fulfilled in the will that he drafted for her. And how do we protect her, that the work that she is paying for and doing in 2023 is going to be upheld in 2027 when she dies?
Right.
I
and
agree.
Yeah, I agree. It's about protecting the public. That's why the state bar exists. That's why the rules exist. They're crafted in the mind of protecting the public that we serve. But I think that you're right. That is the public, the person who's executing the will that doesn't want their stuff challenged. They want their property to go where they intend it to go. And so that's what makes this. It kind of has that counterbalance, right? Because having these sorts of the fees, whether it's a clause that says anybody who challenges loses out on the on their inheritance, or lawyer gets to basically, I guess, charge the estate that's going to ultimately take away from any sort of inheritance. It could be argued that that's a disincentive for somebody to challenge and exercise their legal rights, but then it gets left on the hook, and usually it's the lawyer that's left on the hook for spending, like Mara was just talking about. You know, you spend 12 hours, 20 hours answering interrogatories, doing depositions and all that. So yeah, this one is really tough for me, because I think you can, even if you craft it very specifically, very narrowly, I do see it still being kind of a potential problem as far as what people do with it, which is out of our control to some extent, right? But we still, we don't want to open Pandora's box and say, no, but we're only opening it just a crack. And you can't open the full thing. But like at the same time, I recognize the burden that is placed on estate planning lawyers, as frankly, I feel like it's, maybe I'm getting kind of in a get off my lawn sort of mentality, but it feels like everybody's getting more contentious. And these things are going to continue to happen. This is tough. This is a tough thing.
And I agree. And I appreciate the difficulty Martin and other estate planning lawyers are facing, because it doesn't serve the public if he works this into his fee without expressly putting it in there, but triples his fee, and the testator goes to somebody else who's not as qualified.
Right.
That's not a good position to be in. However, we have to make it very narrow, because if you read Suzanne's proposed opinion, you got the client's estate, which involves, people who are not privy to this contract, responsible for an unknown and unlimited amount of legal fees based on a not yet determined hourly rate. Nothing can be more vague than that.
That's not right.
We can't open that door too widely.
So the only ethics rule we have to guide us is 1.5. Is that correct? Is there anywhere else that, from an ethical standpoint, we can look for guidance other than 1.5?
I don't think so. I think this is a 1.5B, just as drafted in there. And of course, there's consideration of 1.5A, whether it's clearly excessive, but that's not going to come up until after the fee is charged.
Right.
But yeah, it's the 1.5B situation that you're not able. It is too vague. It is simply too vague, and I think that's a question of maybe we can't really address the legal enforceability of any sort of clause, but I think there's a fair question about whether or not it's truly enforceable, because you don't know. Do you have a meeting of the minds in that?
Agreement to agree.
So I have a question that's bothering me, which is, we're saying this is fact testimony, which we all agree it should be, but then we're saying you can charge a legal fee for it. So that seems inconsistent to me. So I'm wondering, is what we're really saying is that the lawyer's services, the fact that the lawyer may have additional services in the future is foreseeable in this type of case, and that this is actually a continuation, an anticipated continuation of the representation. Is that another way to look at it? I am a little worried about, I don't think it's consistent to say it's fact testimony, but you're going to link it to a fee.
That's true.
Yeah, I think you're right, Ashley. And I'm saying legal fee, and I guess I really am meaning some sort of fee that you contracted for fact testimony. That like there's something, which again gets into the whole question of the legality of that. Is there a statutory?
So then is it in this rule at all? Isn't that
Right.
rule just
Right.
fees? Like, could they not just contract to do this outside of the question of a legal fee? I don't know.
I think
I don't
that's the rules on fees under 1.5, it talks about how a lawyer cannot make an agreement for, charge, or collect an illegal or clearly excessive fee. Just fee. Because you have legal fees, you have fiduciary fees, you have different fees that a lawyer can incur. And this is one of those it's so closely tied to the lawyer's services. I wouldn't call it law related services.
It's an ancillary service.
It's that's why this thing is this is a weird inquiry because it doesn't fit neatly in anything that we currently have. But the rule talks about just fees in general in like a broad sense. And so I think that's where we're talking about the, even 1.5B that I was talking about. It says when the lawyer has not regularly represented the client, the scope of the representation, which this isn't representation, the scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible shall be communicated to the client, et cetera. And that's the sort of thing that, it's not, it just doesn't fit neatly because we're not talking about representation. We're talking about some sort of rate of fee. And, do you open the box and say, listen, I don't know whether you can do it. We can respond saying, whether it's legal or legally is the question that you have to do, or you have to figure out for yourself. But this is not something that the ethics rules even opine on. I don't know that we can really go there. I feel uncomfortable with it because it is so closely connected to the lawyer's services.
And I would fear in that regard that we would not be protecting the public because we would be opening up the public to get hit with something that is ridiculous. And then I guess we still have the protection that the client, the decedent still has the protection that either the panel or the executor or the judge is going to pass on this number, whatever it is, under any scenario. So there's always that. Is it ever a situation when y'all run into a problem like this where we could backwards engineer this thing? So could we put it to the estate lawyers to draft the language that they would want in their fee agreements that addresses the foreseeability, that addresses there can't be a clearly excessive fee, that addresses the reasonableness of the fee, that addresses the necessity of the testimony to sanctify or enforce the underlying legal work, and then see whether or not that would pass state bar rules, as opposed to having us figure out what the rule is and then them create the fee agreement that goes with it. Would that be an easier way to skin this cat?
Advisory opinion?
No, just within this subcommittee, could we get some estate lawyers to contemplate what their fee agreement would look like if they were allowed to do this within all the new things that we've talked about? It has to be foreseeable. It needs to be time limited. You can't charge your 20-year later fee, all that kind of stuff, and then once we see what it's going to look like, if we could make sense of it under the rules.
The other thing this is, and I know y'all may be appalled at this, but like in places like Columbus County, I very rarely do a fee agreement for a will. I would spend more time drafting the fee agreement than the will.
Oh,
but you don't even have a fee agreement.
Sure.
I mean, the person comes in and says, I want to have a will. I said, I sit down with them and we talk and I draft the will. It might take me an hour. It might take me 15 minutes. But as far as
Oh
the
my
time doing a
goodness.
fee agreement, you just don't, I mean, there's not time. It's like doing a deed. Okay, come in, I need a deed done. Transfer. Yeah, Bobby's giving this to me. Okay, what are these stamps? Yep, who's gonna pay? Okay, we're good. Sign, done, out the door.
Right.
It's just that
Okay,
quick.
well
It's
then
just
never
that
mind.
quick. Yeah, so
Okay,
I mean, these fee agreements are really, really cool if you're going through an entire estate planning. Now, when I do an estate administration, yeah, there's an agreement there because you come to all these issues. But just doing the will, I mean, they just show up. They walk in off the street. I want to get a will done. And what I'm worried about is, are we going to create something that's a monster that stops me from saying yes?
right,
Yeah.
right.
I'm doing it for $275, but now I can't. I got to charge you $550. And they're looking at it like, what? I say, well, y'all might have to go up here later. What? Well, I don't think you will. I mean, I know we haven't seen my daughter in 10 years, and and we really got off to a bad start with it, but she hadn't come around anymore. She doesn't take care of me. She's not gonna get anything. Oh, well, you live with your son? Oh, he brought you here? Oh, he's paying for your will? Oh, really? Okay, great. Here we go. And you're leaving the beach house doing right. Oh yeah. That's not worth much anymore. It did start out at 20,000 back in the day, but now it's worth 2.5. I mean, it's just crazy.
Wow.
That's the boots on the ground. That's what happens.
So where are we, guys?
This is tough. This is really tough. But I think the judge is right. Bad cases do make bad law. Tough cases make bad law all the time. And we can make a mess, a real mess.
You don't have to issue an opinion. You can say no.
Okay. That might be the thing to do because this one is really
Brian,
sticking.
I mean,
It is,
Yeah.
and if we're the only jurisdiction that's tackled it, they're gonna look at us as a model, and they're gonna look at us to ridicule us.
And it may be that's why we're the only one. Nobody else has been willing to, they come to the same conclusion we have, that it's too tough.
So if
So
you
what does
don't,
that mean? If you do this, we're not saying you can't do it. If you do it,
Right.
then on the back end, you're gonna have to see if the fees
It's reasonable.
is subject to those claims and that disciplinary action.
Right.
Right.
Suzanne, what were you gonna say? I heard you.
I don't remember now. Oh, I think I was going to say that when I can't find anything on an issue, it's usually because it's just so obvious what the answer is, or it's just so hard to figure out what the answer is.
I think the latter for sure.
But I mean, I'll keep trying. I mean, like I said, maybe I put in a different kind of search, but I found that site where that family or whatever that organization was. And then I think I found another article which said, some lawyers might want to put this in. And then there was a sentence that said, but ethics rules might not allow that. And then that was it. There was no other, that was a dead end. So, I mean,
I don't want to give up. I don't want to give up yet. I think that, go ahead, whoever was going to
Okay,
say
Gina,
something.
this is what happens then. So we're not gonna give up, but the question would come up, it would arise. We let it be after the fact. So what sort of hearing happens, Brian, where the attorney has charged a fee to appear, to give this? The result does not come out like the estate wants. So now the estate comes after the attorney to say, you didn't do it right. You charged us for this. Where does that put me? What is my defense if I have one, or what is my guidance? Because I don't know if I've been unethical or not.
You're saying like now you're facing some sort of, whether it's a civil action or disciplinary action, because they basically like you have charged the estate and they're saying, yeah, it still didn't help.
No.
When it's a disciplinary action, it says you've charged an excessive fee.
Excessive fee. But because I charged them $2,000 to have to do these hours with them.
Yeah. Yeah. And I think that would be honestly, from a disciplinary perspective, I feel like the issue is more of just charging the fee in the first place. And that's where I think I've in talking about this when we first got it, where I thought that the answer was just kind of a no, because it was too much of opening the box, right? But if somebody does it, what's the disciplinary thing? Yeah, they might go after the fee itself. I don't know that they could go after the person for charging the estate, because again, we're getting that thing that it's not legal services provided. You know, it's not a diligence thing. I think it'd be focused on the fee itself as opposed to whether or not you did a good job. But it might be civil liability. They may sue the lawyer and say you were ineffective in your defense of this document. Is that malpractice? I mean, now this person, I don't know if it rises to the level of a malpractice claim, because it's just fact testimony, and their fact testimony was horrible. It came across poorly. You know, it would be so circumstance dependent. It's just hard to kind of anticipate what would happen. But yeah, you could see all that stuff. And I think that's where, when I started carrying out, what if you say yes and you allow this? How does it get applied in other areas? Even if you say it's not supposed to be applied in other areas, what's the kind of that ripple effect of down the road, like you just articulated? Somebody's still upset with me, but I've now charged fees. And wondering right now the current way to deal with this, and Martin, please tell us if there's other ways, but it sounds like lawyers can perhaps apply for some sort of compensation for the time they spend, and they have to apply to the clerk and try to get something from the executor. Maybe it happens, maybe it doesn't. Most likely it probably doesn't. I would guess that's most of the time that the executor says we don't have the funds.
Because of the priority issue.
Right. It's a priority.
Right.
Now, one thing that does get really, really fun then when you've got all these bills, but not anything, but maybe you do have the house, is then you get to a petition to sell the house and generate funds for the estate. And then there's a whole fee going on. This is really fun. And that happens regularly too.
So is the answer not an ethical one? Is it a legal one? As in, and this is something I want to be clear. I don't think the state bar can take a position and lobby for any sort of legal change here. But that's where I guess I'm trying to vet whether or not this is an ethical issue by asking the question, is this more of a legal issue? Like if there was a statutory change that said, you know, essentially lawyer time spent defending the document is an administrative expense of the state or something like that. Like, is the solution not through the ethics rules, but it's actually through the law, is my question.
Legislative change proposing that the non-prevailing party pay it, or have a statutory amount that could be paid, and that could change over time. Right. Those are things we can't wade into.
Right.
No, and there is kind of a saving grace in that the clerk does look over this. I mean, there is someone else there independent to be able to say whether it's allowable or not. And they're and they can be strict on that if they want to. And of course it speaks to advisors. I'm not sure if that's, but it could be, or it talks about agents. It's anybody who is representing to, as Brian said, to help to prove that this is the intent of the decedent. This is it. That's kind of like Gina said as well. Don't we want to protect the decedent? Because the decedent is the main one here.
Right.
They have done the will. They've done everything they thought was right. Now, I know y'all probably see these things that come up as well. You do have people that come in that are very questionable. It happens a lot with dementia. And of course, dementia is in stages. The first stage, you've been diagnosed with dementia, but you're in stage 5 or stage 1. I can't remember which one's the opposite way, but it goes where the dementia is not all the time. You have these wonderful moments of clarity when you know exactly what you're doing, and you can tell them what happened in 1920 as well as what happened in 1923 or 2023. And that's great. But then as they progress through time and you get closer to that point of no return where you say, no, I'm not going to do this anymore, because I've had to do that before. I've had to pull back and say, look, Mom was great when I talked to her in the office. I know she had to go inpatient for just a little bit. She's out at Liberty. She's getting rehab. I'll go talk to her. And when she's at Liberty getting rehab, that's not Mom that I talked to. And so then I've got to make a choice. Or it could be it's a UTI. And they're talking out of their head. And for that little time that's when the other party happened to go visit Mom. And she told them that, the sky was purple. But that was because of a UTI. Nobody looked at that, but everybody else knew. And then, of course, they get fine. They get their wits back about them. And then they go back out. And they're fine for a little while. But dementia's still there. And so it is hard, y'all. I tell you, it is so hard. And they come in and you're going to charge them $275 for all this. It's tough. And they're looking at you and they don't like it. And, you know, the kids say, no, mama didn't know what she was doing. There's no way. How could you ever do it? And, you know, the good thing is normally when you're defending it, and this happens with the civil as well, because they'll file, like I said, they'll file the caveat, but they'll also file a claim to set aside anything that was done with the power of attorney that they were using ahead of time, that was usually done at the same time. And so that's where the civil liability comes in from the attorney's perspective, not so much the estate, because you're defending the estate. If it goes away, the will, then you fall back to either the prior one, or if there's no will, then of course it's intestacy, and you still got the clerk to be there. But it's that civil action you got to watch out for, because that's where they say, well, you should have known better than to let mom sign that durable power of attorney to let me open the bank account and have a good time with it. It's a mess. And that's not helping us, I don't think, but that's kind of the lay of the land, is what you see. And I know we started talking about this rule, that was one thing that I really kind of, you know, I know we want to help the estate planners, but estate planners also do powers of attorney. And so that, you know, and you see those two lawsuits come right, or two things come right together. You do the caveat and you see the lawsuit, and you see the lis pendens or the attempt to get a stay.
So I was thinking that the difference would be if there was an issue about an abuse of a power of attorney, that the declarant or whatever you call the person is still going to be alive. But you're saying after so there's no statute of limitations on when you can go back and undo transactions under a power of attorney?
There could be potentially, if it's a deed that's been signed, you've got 10 years under seal. If it's a breach of contract, it's about 3 years. But you, in essence, would have a 10-year period of a look back. And normally this doesn't happen in 10 years. This happens in the last 6 to 9 months, maybe the last year of life. Because they're getting down, everybody realizes they need to move quickly. Yeah. And that's when the really bad ones happen, that's when it happens. You know, or someone's the power of attorney and they have not been doing anything for years. And suddenly mom needs it. They moved away to Oregon and they need to have somebody else put in. So brother steps up and says, well, I'll do it because you're staying here with me. So they revoke the prior power of attorney, put that one in, and suddenly brother goes crazy. Or maybe brother doesn't go crazy, but sister who's in Oregon thinks the brother goes crazy. And that's where the lawsuit comes in. And the neat thing, though, that we have finally convinced most judges to do is that, and it really works, however the power of attorney would go is dependent upon the estate. If you succeed in the estate and the will is upheld, then normally that will end any abuse on the power of attorney. If you lose the caveat, there's a really good chance that you're going to lose on the civil part as well. And that's just not a rule of thumb, but it's kind of a guidance to us. So we'll most likely, we'll seek to have a stay of the civil action while we're litigating the caveat, because there's no sense in dealing with until you know who wins. And then you can go back and deal with the other. But yeah, there's a long time period. It can be up to 10 years.
Okay.
And I'm not helping y'all a bit.
No, you really don't, man. You blow my mind. Every time we have one, I don't ever want to be on the subcommittee with him again. And just blow.
I just make a mess. It's not easy.
Oh, you wear me out, man. Well,
We've
we're
gone
at
from
our
no to yes, back to no.
right.
Yep. Yeah.
So I don't want to give up yet, particularly because Wade and Heidi are not here today. And Wade and Heidi were on my yes bandwagon hard at our last meeting. So I would like the opportunity for maybe Suzanne, if you could send us sort of a State of the Union report about this meeting and CC them. And then maybe we could have a talk with them, because I don't want to, go from one extreme to another extreme without all the subcommittee members being able to weigh in when they were as plugged in and opinionated as those two were.
Yeah, it's true.
Okay, well, let's call it a day. Let's do that. And then let's try to reconvene this party before the October meeting, just to see if we're all still in the same mindset. Is that okay, Suzanne? You're
yeah,
rubbing your
sure.
brow.
I'm just not sure what the mindset, but yeah.
I was just going to say, I thought what Ron said about maybe it's not an ethic thing, but a legal or statutory, I mean, that kind of resonated with me. Not that I don't want to get the yes, but maybe that's why we're having so much of a problem.
right.
Suzanne, if you'll send that clerk's manual, that sheet I sent to everybody, if
I
y'all
think I
will look,
did. I
if
think I
you'll
did.
look under provision 4, under attorney fees and other expenses, it does have a catch-all. And that's where the clerk may allow reasonable sums for necessary charges and disbursements incurred in the management of the estate. You know, is this broad enough to be a management of the estate issue? Could this be allowed?
Now, if
Maybe.
it's a caveat, it's going to be before a superior court judge. Are they bound by that?
Exactly. Yeah, it would be. But this, now the clerk keeps some things though. What happens is almost like a dual situation. The regular ongoing estate is still administered. They can only do things like filing accountings. They can't do like big distributions. They can pay necessary expenses and fees, and there's some petitions you do for that. Whereas the caveat takes over the big part. But yeah, so there's kind of a dual jurisdiction.
Okay.
On
Sorry.
that note. All right, guys. Thanks, everybody.
All
Thank
right,
you.
Yeah.
Very thoughtful discussion.